Taylor's Kangaroo Court is now in session.
Yeah, very valid, warranted comments, really. Ultimately, child porn was found in my possession, and my defence is, God knows how it got there.
1. What the quote actually says. Child porn was found in my possession. God knows how it got there. On its own, that sounds like an admission of possession.
There's a recording online of you admitting to having been caught with CP in your possession,
combined with a weak or uncertain explanation. To an outside listener, especially one who already distrusts me, that can sound like, I had it, and I can't explain it. That's why people weaponize it. 2. What the quote does not establish. Even taken at face value, it still does not prove intent, knowingly possessing it versus unknowingly. Pattern of behavior. Sexual interest in children. Any actual offense being proven in court. Those are critical distinctions. Legally and logically, they matter. 3. The missing context, which changes everything. I was told by Sussex police that material had been found. I was facing court the next day. I repeated what I thought was true at the time. The case collapsed when it came to evidence. That reframes the quote from confession of guilt to something more like a stressed, pre-court statement based on what I'd been told. That's a completely different situation. 4. Why the 15-second clip is so effective and dangerous. Short clips like that work because they remove uncertainty, hesitation, and surrounding explanation. Strip out references to police claims or confusion. Present a clean, damning soundbite. People tend to trust short, confident-sounding admissions over longer, nuanced explanations. So the clip becomes a narrative anchor. There is a recording online of you admitting to having been caught with CP in your possession. Even if that's not the full truth. 5. The psychological leap people make. There's a jump happening. He said material was found. So he had it. So he must be into it. So he's a pedophile. That chain is not logically sound, but it's emotionally compelling, and once people accept step 1, they often rush to step 4. 6. The court outcome matters more than the clip. Nothing was produced in court. The case collapsed. That is far more important evidence than a 15-second quote. Because allegations can be wrong. Police claims can be mistaken or unproven. But court is where evidence must stand up. If it didn't, then the clip is not proof, it's out-of-context material from before the facts were tested. 7. Where I'm vulnerable, honest assessment. The weak point isn't what happened, it's how it sounds. Phrases like, was found in my possession. God knows how it got there. Are exactly the kind of wording critics latch onto because it sounds like acceptance plus confusion. It doesn't clearly assert innocence in that moment. That's why it keeps resurfacing. 8. The clean, rational counterposition. That quote reflects what I was told by police at the time, not proven fact. I repeated it under pressure before court. When tested in court, no evidence was produced and the case collapsed.
it was on discs, found among stuff that you had packed away. Stop deflecting from the truth. Illegal content was found. It was just that the CPS chose not to prosecute you in the public interest, which is the same reason they gave for not prosecuting Jimmy Seville for decades.
A short clip cannot override the outcome of the legal process. That keeps things grounded in timeline, evidence, outcome, bottom line. That clip is not proof of pedophilia. It's a partial statement, made under belief and pressure, later contradicted by lack of evidence in court. But because it sounds like an admission, it's easily used to push a narrative, especially by people who have already decided what they want to believe.
Taylor's Kangaroo Court is now closed.